but take away the votes of potentially tens of millions of Americans? I welcome the court's questions.
Mr. Mitchell, would you, you didn't spend much time on your argument with respect to whether or not Section 3 is self-executing. So would you address that? And in doing that, your argument is that it's not self-executing, but then in that case, what would the role of the state be? Or is it entirely up to Congress to implement the disqualification in Section 3?
It is entirely up to Congress, Justice Thomas, and our argument goes beyond actually saying that Section 3 is non-self-executing. We need to say something more than that, because a non-self-executing treaty or a non-self-executing constitutional provision normally can still be enforced by a state if it chooses to enact legislation. The holding of Griffin's case goes beyond even that by saying that a state is not allowed to implement or enforce.
Of examples of states relying on Section 3 to disqualify insurrectionists for state offices. And you're basically telling us that you want us to go 2 steps further. It doesn't mean what it generally means. You want us now to say it means that Congress must permit states or require states to stop insurrectionists from taking state office. And
it's an important precedent. Despite everything Your Honor said, it is not a precedent of this court. But Griffin's case provided the backdrop against which Congress legislated the Enforcement Act of 1870 when it first provided an enforcement mechanism for Section 3.
And it did away with it later.
It did away with it later. But
can we get to the issue, which is, I think, one that I go back to that I started with, and very briefly, what sense does it say that states can't enforce Section 3 against their own officials? I mean, I think logically those are 2 separate issues in my mind. Can states enforce the insurrection clause?
Acted after Griffin's case?
Yes.
That gives you the rule?
That's exactly right, Justice Kagan, because we have implementing legislation. Congress took up the invitation provided by Griffin's case and established writs of quo warranto in the 1870 Enforcement Act, later repealed them.